Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley. Appreciate you joining today. Today, what we're going to talk to is the next series of financial issues. We spent a lot of episodes, probably the last 5 episodes, talking about child-related issues after kind of starting the year, just dealing with topics of getting started and even starting the process. So, financial issues, there's a lot to this. So there'll probably be a good 3 or 4 episodes. But today I'm going to start with what seems like a real basic concept, but there's some nuance, and that is the concept of marital versus non-marital property. So again, I'm coming from a perspective here in the state of Illinois. And in the state of Illinois, the governance of personal property, real property, financial property, assets in general is all guided by Section 503 of the Illinois Marriage and Dissolution of Marriage Act. Fundamentally, what the statute here says is that marital property shall be divided and allocated equitably, meaning the court gets to look at the contribution each party made to the acquisition, preservation, and maintenance of those assets. So what does that mean, equitable distribution? Well, equitable in a general sense as it relates to division of assets really deals with the concept of fairness, and doesn't mean equality, right? It means something that is fair in the circumstances of that particular marriage. So, for example, we hear the concept of non-marital property and marital property. Now, if the court is only dividing marital assets, implicit in that is that the court does not have authority here in Illinois to divide one's non-marital asset. Well, what's a non-marital asset? So let's start there. So a couple of buckets that you can think of for non-marital assets. Number one, simply put, it's an asset owned and acquired by an individual prior to the marriage. Another bucket, so to speak, of non-marital assets is money that is inherited. So if you are married and even during the marriage, say your father or mother passes away and you receive an inheritance, even though that is during the marriage, that's exempted as non-marital property, okay? And there's some more detail we'll get into how to manage those issues, how to make sure that if you receive, for example, an inheritance during the marriage, that you keep that segregated. But again, another, concept of a non-marital asset, another bucket, would be something that is gifted to somebody, and that's regardless of whether it's before or during the marriage. So this concept of before and during the marriage is important because in Illinois, there is a legal presumption that an asset acquired by either party absent an agreement to the contrary, meaning if you did a prenuptial agreement, you can change the rules. But absent that, assets and income for that matter acquired during the marriage are presumed to be a marital asset. Okay, so the presumption is there. Hey, you got $100,000 during the marriage. That's a marital asset. Okay. The presumption can be overcome by the person who received that $100,000 by establishing evidence that it was a gift or it was inheritance. So understand, you start by saying, when was the asset acquired? Was it acquired during the marriage? If it was acquired during the marriage, the court's going to look at that and say, we presume it's a marital asset because you got it during the marriage. Okay? Then it becomes that individual's legal burden to, by clear and convincing evidence, establish, or preponderance, that the asset in question was acquired in a way that the law acknowledges to be non-marital, which again could have been through an inheritance, through a gift. Well, how do you do that? Well, if there's a will, if there's a trust, if there are a probate action or something that acknowledges where that source came from. So again, documentation is really critical at any point in time when you're trying to establish something to be non-marital. Inheritance is usually pretty straightforward. You know, the asset is conveyed to you from, for example, your parents' name. The funds come from an executor or someone, an administrator of a trust. So, but again, you need the documentation to do that. Gifts, that's an interesting challenge. If something is a gift, how do you prove that it was in fact a gift? Which, by the way, you could receive a gift from your spouse during the marriage, and as such, that counts too as a non-marital asset. So let's imagine it's, a large anniversary, 25-year wedding anniversary. And let's just hypothetically say the husband buys huge diamond earrings for his wife, celebrating the 25th wedding anniversary, spends $50,000 on diamond earrings. And then a year later, they're going through a divorce. Those diamond earrings are non-marital assets because they were a gift, okay? How do you establish that? Well, here's the card that came with it, saying, I hope you like the earrings. Here's the receipt, and it shows they were purchased a month before our 25th wedding anniversary. Here are the photographs of our celebration where, he was presenting me with these. So again, you have to always be thinking, how do you prove your non-marital claim? It's your burden. When you start talking about the first bucket, which is assets acquired prior to the marriage, it's the same challenge, and oftentimes it's more difficult because, say, for example, you have the 26-year, 27-year marriage, and an individual has a property or has some type of retirement account, for example. We'll talk about that because it's somewhat unique, but has a property that they had prior to the marriage. And then during the marriage, they sold that property and they bought another one and they kept it in that spouse's name. That's another area that in Illinois, the law recognizes to be non-marital. If you have a non-marital asset and you utilize the proceeds from that non-marital asset to acquire another one during the marriage, assuming you don't change title, that also can be a non-marital asset. But again, it requires you being able to have your closing statement, your title, your deed, something from 27 years ago, or maybe it was 30 years ago, even 3 years before you got married, that you bought that piece of property. So documentation is critical in establishing any non-marital claim. When you have a combination, and I'm going to use real estate because I had this happen in a case recently. So the gentleman we represented had real estate in his name owned by him prior to his marriage. Then he gets married, and into the marriage, I don't know, a year, 2 years, they decide they were living in his non-marital residence. They decide, let's buy a bigger house. Very common. He sells his non-marital home and then takes the proceeds from that and puts that into the home that he buys during the marriage. Well, in doing so, they also had some marital money that they put in. So say, for example, it was $200,000 that from the sale of his non-marital property that goes into the purchase of the home. Then, as a married couple, they saved, they earned, she put some money in, whatever, she was working, he was working, they put in another $50,000. So $250,000 goes into the house, bought during the marriage, and it's jointly titled. What happens? Well, the jointly titled property acquired during the marriage is not only going to be presumed marital, it will be found to be marital. So you say, well, then what happens with the $200,000 that I can show, and which we did in our case, came from that person's non-marital asset? Well, it, number one, begins with establishing that you own the property prior to the marriage. Pretty easy, again, closing statement, deeds, titles, so forth. We've got that. Number two, that you can then trace, again, you want to make sure you have documentation, the flow of money from that sale of that non-marital property into the purchase of the newly acquired marital property, right? So again, banking records, wire transfers, closing statements. Here's the exact number from the closing of my place that I had before the marriage, and here's the wire transfer for that, or it goes into my bank account, and then from my bank account that same amount goes into there. Okay, so establish it's before the marriage. Number two, clear tracing of the money from that non-marital into the marital asset. The combination of utilizing non-marital money into the marital asset doesn't change the marital asset into his non-marital. What it does in the law is it creates an argument that the person with the non-marital can claim reimbursement. So he says, on behalf of my non-marital estate, I'm asking the court to reimburse me the money that I put in. Because again, as I said before, Section 503 instructs the court rather, to consider the contribution each party made to the acquisition, preservation, and maintenance of an asset. Well, if in that hypothetical, which again was a case we tried, the husband put his $200,000 of clearly non-marital money into a marital asset, it's impossible for the other spouse to argue that she had any contribution beyond the $50,000 they put in, some of which was through his earnings as well. So his contribution was clearly identifiable. The amount of it was clearly identifiable. And it's not as though she met that contribution with something of her own. So in that instance, what the court did, and let me digress because I mentioned this earlier, a court has the ability, and I shouldn't say ability, has the discretion to then determine really kind of whatever they want in terms of that reimbursement. What's equitable? Because a judge could have the discretion to say, sir, I'm going to reimburse you $200,000 from the sale of the proceeds of the house. Because again, the house then accumulated in value over the years. There was more equity. I'm going to give you the first $200,000 back. But then because I have the authority to equitably divide the rest of the proceeds, the court could say, I'm going to give the wife 60% of the proceeds because he's got some non-marital assets that she does not. And so it's never as cut and dry. I shouldn't say never, because the court also has the authority to say, sir, you get your $200 off the top, and the rest of the equity, we're going to split 50-50. Okay? A court could look at it and say, you put your $200,000 in, and the equity from the original $250, because 50 of the marriage went in, it now doubled. So the percentage increase of the equity, a court has the authority and could equitably decide that you also get a particular rate of return back on the amount that you put in. That rarely, if ever, happens. Okay? But the concept is, just because you took a non-marital asset and you merged it in with, or you created a marital asset, doesn't mean that you lose all your claim to that. Okay? And that's where the beauty of I think Illinois law is well constructed, because it takes these concepts and recognizes that going into a marriage, you may not understand that when you're taking your clearly non-marital asset and pouring it into something during the marriage, that you're giving it to the marriage. There has to be some donative intent. And that's something where, for example, I mentioned these buckets of non-marital assets. You can lose a non-marital asset by gifting it to the marriage. So, for example, say one of your parents passes away and you receive $1 million, and you say, you know what, even though this is from my parent, I want our family to enjoy this. We're going to take vacations. We're going to, buy a vacation property. We're going to buy some new cars and so on and so forth. You spend the $1 million over 10 years of your marriage. And at the end of it, you say, wait a minute, we're getting divorced. I used my $1 million inheritance. Your parents are still alive. You haven't had an inheritance. Mine's gone. I want it back. This gets far more complicated because, number one, when you choose to spend it in a way that benefits the family, not in a way that's necessarily acquiring an asset, the money's gone, you're not going to get that reimbursed. If you say, well, we acquired a summer home with some of the money that I inherited, and here it went from my account into this property, and it's a joint account, you have your reimbursement claim for that. But if you really say, and it's really in your heart, that your intention is, you know what, I'm going to take this inheritance, this $1 million, and I'm going to put it in a joint account during the marriage. Because spouse A can use it, spouse B can use it, we can use it for stuff together, we use it to fix the furnace, we use it to do this and that, took a vacation, bought a new car, it's the car I'm driving, it's not the spouse who inherited the money. You risk not only losing its non-marital identity, but what you do is you potentially lose the ability to seek reimbursement, okay? So that's something you have to be very, very careful about. If you receive an inheritance, and that is your family's, or a gift from your family, and this is really what they wanted for you, you then have to be sure, as a starting point, keep that segregated. The choices you make with that money is yours to make, and that's something that, again, in every given marriage, it's going to be different how you treat that. But if you get that $1 million inheritance and you put it in an account in your name, and you never put your spouse's name on that, for all intents and purposes, that $1 million account is going to remain as your non-marital asset. So it's very important in terms of how you choose to hold assets. It's no different than, again, I'd said before, if you had a non-marital property that you sold during the marriage, but you wanted that new property because you were the one putting all the money into it, you wanted that to remain non-marital, then you would want to keep the title in your name alone. So when you get into these kind of issues, most people should be watching this podcast, number one, because then they can have some idea as to understanding how this works. More importantly, you're going to know, I really ought to call Quigley because this is something that's somewhat confusing. I don't want to make a mistake where I take this property and I lose it because this is the only inheritance I'm going to get. So another issue even that sometimes we encounter with sort of non-marital issues is gifts. So oftentimes we see a grandparent or somebody, let's imagine you have spouse A and B, and spouse A has 3 siblings, so there's 4 kids, and spouse A's parents every year give them X number of dollars to all 4 kids. Well, spouse A is obviously married. So when they give the money, are they giving it really to just their child? Are they giving it to the couple? What happens with the money? Where does it go? How is it handled? All these same rules apply, right? If spouse A's family gives $100,000 a year to each kid, and when spouse A gets his or her $100,000, set it in a separate account. There's no earnings during the marriage going into that. There's no other investment money from the marriage going into that. It is a sole and separate account that those gifts go into each year. That's going to be a protectable non-marital asset. If that money goes into a joint account every year, even if the check is written to spouse A and spouse A just deposits it into each year into this joint account that they use for stuff, vacations, cars, bills, then you're going to lose the non-marital classification of it. So, again, just to sort of recap, non-marital, when you get an asset, if it's before the marriage, make sure you keep your documentation. Keep clear records. Some people come to me and say, I need a prenuptial agreement. Why do you need a prenuptial agreement? Because I want to protect this asset. The asset's already protected. You could do a prenuptial agreement, but unless you're someone with great wealth, and there's a lot of other reasons to do your prenuptial agreement, if you're really just trying to protect a singular asset, you may not need to go through that exercise. I never say to somebody, don't do a prenuptial agreement, but it's kind of belt and suspenders if you have somebody that clearly has a non-marital asset in that person's name prior to the marriage. The advice I always give is make sure you get a digital copy, get a hard copy, keep a copy in a safe deposit box, so that if it ever does come up, hey, did you have this before the marriage? I've got my evidence. It's there. It's locked away. Now, one other thing that's important to think about is when I talked about equitable distribution before, I hope that I've made clear that if you have non-marital assets, they are yours. They always will be. Your spouse in a divorce cannot and will not get them. But there's a way that the court can equitably then account for the fact that someone may have a large non-marital estate in dividing the marital estate. In other words, because again, it's not 50-50, it's equitable distribution. Here's an illustration, and this was a case we tried in DuPage County, and this was actually, at the time, one of the largest maintenance awards that was ever was ever ruled as part of a contested trial. But in the property division, it was very interesting because the husband in that case had been gifted shares with two of his brothers during the marriage of a large company, very, very valuable company. And so what was interesting about it is it was pretty clear that it was from father to sons during the marriage, in the son's name, not spouses. It was clearly a gift. There wasn't anything where the sons had to buy into the business. But where it got interesting was during the marriage, then thereafter, two of the brothers bought out the third brother. And it became a question of the money that was used by the husband to buy out the brother, because that was during the marriage. Our argument was he used marital money to buy those other shares, and those shares in that case, therefore, that, let's say there's 100 shares total, and each got 33 shares, 33.33 shares, and then the two brothers bought the other brother's 33.33 shares so that they each got, whatever that number is, 16, 17 extra shares. So we were able to trace the funds used from a joint account purchasing those shares from the brothers. So we were able to really establish that those should have been viewed as marital shares. Now, what was interesting in that case, the case wasn't appealed because we did very well in pretty much the larger picture on behalf of our client. But what the court did is the court ostensibly reimbursed the marriage for its contribution towards that non-marital asset. I think the court, it did the right thing in the wrong way, but there was some credit given back to the marriage. So, but at the end of the day, what happened is because husband's shares of this company were so valuable, I mean, it was somewhere in the neighborhood of $70-some-odd million was the value of his interest in this company. So that's a massive number compared to what the marital estate consisted of. And the marital estate may have been, under $10 million, but still some good money in the marital estate. So what the court did in that case is two things. One is they understood that because of the great wealth husband was going to have and was going to only get greater through the years, there was a very, very large maintenance award that was given to our client because we were able to establish the lifestyle that she enjoyed through the years of marriage. They had 4 children. And so the court not only awarded a significant maintenance sum to our client, which was permanent, but the court then went further and in distributing the marital estate, didn't say 50-50 on that. They awarded our client probably close to 75% of the marital estate. So our client got a lot more of the marital estate, what was liquid. There was a huge piece of real estate that was it was heavily encumbered, but it was very, very valuable. That was awarded to the husband because our client wasn't going to be able to maintain that anyway. So ostensibly, he walked away with this monstrosity on the lake, and our client received basically all the liquid and cash assets and had a considerable amount of money coming to her on a monthly basis with this maintenance award. So it worked itself out. But the idea being that the court can adjust the marital estate equitably, fairly, in a way that takes into consideration, sure, one party's getting way more of what was acquired during the marriage. Why is that fair? Because the other spouse has such tremendous wealth that it's not going to matter if you got an extra 10% or 20% or 25%. So it's enough to say that non-marital assets are in any case, the minute you are even thinking about a divorce, you always have to think about what documentation do I have to establish something non-marital, and then what arguments do you make if there's transferring or commingling of non-marital into marital or marital into non-marital, as was the case in the case we tried. And then what arguments can you make? You have to rely on the courts to be fair and equitable. It doesn't always work out. Listen, somebody who has a substantial non-marital estate is clearly going to be better positioned economically because that's their money, that's their family's money, and that's just something that for some people it's hard to swallow. It's hard really to kind of grasp. But you always got to think about the starting point, which is what's non-marital, what can we prove is non-marital, and then you go from there in terms of making the arguments of adjusting and requesting a disproportionate split of the marital estate. So there's one other thing that we see quite frequently that before I go, I want you to think about, which is retirement. Retirement's treated a little differently. So many of you listening or watching have or are working a job, have retirement benefits, whether it's payment into a pension, which we talk about as a defined benefit plan. So a defined benefit plan is the old school pension. Police pension is a good example. When you retire, you're going to get X number of thousands of dollars per month. What happens with someone's working and they've worked for 10 years and they have either that type of defined benefit plan or a defined contribution plan, which is similar to a 401k, 403b. You hear these where sometimes companies match, sometimes companies put a percentage in on your behalf. But you have a plan that when you retire, you've got $1 million in the plan. When you take that out, how you take that out is up to you. That's different than you getting $5,000, $8,000, $3,000 per month, whatever that may be, okay? But the concept is the same, no matter what type of plan you have. If you've been working and accumulating retirement benefits prior to the marriage, to the extent, again, you can prove that with some kind of documentary evidence, you will be able to preserve your own non-marital portion. Well, how do you do that? Well, again, I mentioned there's two different types of plans. So the defined contribution plan is really easy if you keep good records, right? So if I get married on July 1st of 2023, and I've been working for how many ever years, but I know that as of June 30th, I have a statement that I've saved digitally. It's in my safe deposit box. It's put away forever. And that statement says that in that plan, I had $500,000. You've just preserved your $500,000 no matter what happens with respect to that retirement plan in the future. So again, I keep harping on this, keep documentation of this, but that person, let's say, continues into the marriage and for the next 10 years continues to either have the company pay in or the employee matches. There's all kinds of different ways you can build a defined contribution plan to where now the entire plan is worth $1 million. Okay? Well, you can hire a financial expert and you can try to, depending on perhaps how you hold that asset. In other words, if you've got a particular stock and that stock stays the same, and you can see how the stock grows over the year, perhaps you can make the argument that my $500,000 was comprised of 100 shares of this particular stock. You could perhaps make an argument that the gains on that $500,000, because I can track the stock, should also be my non-marital. It's a little more complicated, definitely requires a forensic analysis and clear and convincing evidence on something like that. So you can make that argument. More often than not, what happens is the courts look and say, you've got that statement, $500,000. That $500,000 is yours, and then the remaining $500,000 in that plan gets divided. And again, could be 50-50, could be 60-40, 55-45, depending on other factors. But all we're talking about dividing is the marital contributions. I've got the statement that says I had $500,000 in my retirement, in my 401k prior to the marriage, okay? Pretty clear, but you got to have your documents. With respect to a pension, it's a little different because there's a formula here in Illinois, and different jurisdictions use different formulas and different analyses. But the concept is the formula takes into consideration the years of service in your entirety. So in other words, let's say you're working union job, you've got a pension. 10 years in, then you get married. Then you're married for 15 years. And then you work another 10 years on the back end. So I've got 10 plus 10 on the back end, 10 before, 10 on the back, that are non-marital. I got 15 in the middle. Well, the entitlement of the spouse in a divorce is only to the marital portion. So the formula basically takes into consideration the total years of service paying into the plan and the number of years of marriage, and it computes the percentage of the total plan that would be the individuals in a divorce. And what happens with that, again here in Illinois, we have what's called a qualified domestic relations order. It's a particular order that is served upon the plan administrator as part of the divorce with the judgment, basically saying, so I get 50% of 40% of the entire plan. Again, these are not accurate percentages, but to explain the hypothetical, and therefore the plan administrator has to calculate out which is going to be somewhere in the neighborhood of 20% of the total payout, and that would be reflective of 50% of the marital portion. So it could be that if the payment, had there never been a divorce, would have paid out to the plan participant, let's say it would have been something like $6,000 a month. Well, or make it $10,000. It's easy because you have $10,000 a month. But instead, as a result of being married 15 years and the 50% of that marital portion, actually the spouse who worked will get $8,000 per month, and the spouse through the marriage would end up getting $2,000 a month, and they get separate payments. And again, there's all kinds of rules. It gets very complicated in terms of some plans. If the plan participant dies, the plan goes away. You're not married, you don't have a spousal benefit, you don't get that. So, and that's always something to think about too. That's just a little tip. If you're thinking about it and you're negotiating a pension, you need to know if it's the type of plan, if your spouse dies, do you still keep getting your money? Maybe you want to have the plan, you want to do a present day value of the plan so that you could cash out and maybe do an offset and take assets somewhere. So, but the concept is the same. And the takeaway when we talk about marital and non-marital assets as we are today, the concept is the time that you work before you get married and the time you work after are going to be your non-marital assets, just a little bit less clean because if you continue to work at the same job, you don't get a second or separate retirement plan. Hey, now I'm married. You go to your HR person and say, start me on a different plan. It doesn't work that way. So there's a lot of nuance to the concept of non-marital property. And it gets even more nuanced and sometimes a little tricky when you take non-marital assets and you commingle them and blend them and deposit them and mix them with marital assets. And so you always want to make sure you start with talking to your lawyer and saying, hey, listen, I had this before the marriage. Hey, I bought this before the marriage. then the conversation shifts to how do we prove that? What evidence of that do we have? And so it's a very important thing because many of you work very, very hard for a long time or receive inheritance, all of which, again, before your marriage, these are things that should be taken into consideration if there's a divorce and you had those non-marital assets. So again, always consult with an attorney. Highly recommend you contact me anytime because these are important issues, sometimes from a family legacy standpoint, but also just purely economic. And you want to make sure that you're protected. So feel free to call me anytime. Again, I appreciate you following along and listening today. This is kind of the starting point of what we're talking financial issues, and non-marital assets is right at the beginning and a very, very important issue. So as I said before, feel free to call me anytime. Happy to conference with you. My direct extension, as always, is 312-621-1225. You can shoot me a quick email. Happy to schedule an appointment or a consultation. Quigley at beermannlaw.com. B as in boy, EERMANNLAW.com. Thanks again for joining and watching and listening. Look forward to seeing you at the next episode. Take care.